Well, greetings to everyone. Welcome to the distinguished guest lecture of the CIL eAcademy. And today we are really delighted to have someone very special, not only a renowned scholar, but also a very good friend and dear colleague of Patricia and myself. So it is my great pleasure to welcome Professor Concepción Escobar Hernández. She is the Special Rapporteur at the International Law Commission on the subject of immunity of state officials from criminal jurisdiction. She is also a professor of public international law in Spain and Madrid at UNAD. She has been legal advisor to the Ministry of Foreign Affairs. She has been a professor at the School of Diplomacy at the Ministry of External Affairs. She has represented Spain at the ICJ. She has an extremely extensive CV. She is really very well known, professor of international law. And we're absolutely delighted to have her today to talk about her very important work at the International Law Commission on immunities. Dear Professor Escobar Hernández, the floor is yours. You will lecture and then we will have question and answer afterwards.
Thank you very much. Thank you, Professor Oral, for this kind introduction. Thank you, Patricia, the Professor Galbao-Teles, for inviting me to this to participate in this program of e-learning. I have to say that my own university is working on e-learning, so I am very accustomed to do that. But this morning, being in New York, I have had some difficulties for the connection. Sorry for that. Thank you for your kind introduction, and Nilofer, but is the introduction from a friend in particular. I know that you are working this week on the issue of diplomatic and immunity, in diplomatic and immunities law. I will focus in particular on one specific issue on immunity, which is a specific kind of immunity, which is the immunity of the official from foreign criminal jurisdiction. It is probably one of the most important issues now in the international at the international level regarding the immunities. It is an issue that of great interest for a state, but at the same time is a topic very controversial, very sensitive from a political perspective, and at the same time, it is very difficult from a legal and technical perspective. This year, I have the honor to say that the International Law Commission started working with this topic in 2007 by appointing as a special rapporteur the Ambassador Golodkin from Russia, and he works as a special rapporteur for 5 years, and in 2012 I was appointed as a special rapporteur at the moment when the Ambassador Golodkin was no longer a member of the commission. I have been working for 10 years on this topic. The work has been a hard work, not only for me but for all the commission, but fortunately this year we have been able to adopt a draft articles, a full set of draft articles with commentaries in first reading. I think that it is a milestone, a very important work of the commission. As I don't have enough time because of the time allocated to me, I will try to explain you what has been the work of the commission. I will try to put in context the draft article, and after that I will focus on several key elements which are for me the most important elements that characterize the project adopted by the Commission. As you know, the Commission has been working, the International Law Commission has been working on the issue of immunities from a long time. For a long time, the Commission has addressed the immunity of a state official in the past in the context of diplomatic and consular relations and immunities, special missions, relation with the state and international organizations, and immunities of a state and their property. In addition to that, the Commission has considered the question of immunity when examining other topics related to the criminal responsibility of individuals, including in particular the Nuremberg principles and the different projects that culminated in the adoption of the draft code of crimes against the peace and security of mankind, and more recently, the draft article on prevention and punishment of crimes against humanity. The present draft articles take a very different approach than the above, by specifically addressing the immunity of a state official from foreign criminal jurisdiction. These draft articles define the general legal regime applicable to this type of immunity, which is distinguished by the following feature. First, it is limited to immunity from criminal jurisdiction. Second, it is limited to foreign criminal jurisdiction and does not affect the legal regime applicable before international criminal courts. And C, it covers all state officials, regardless of their position or the specific functions they perform from the state, with the sole exception of those state officials covered by special regimes. In preparing the draft articles, the Commission has taken into account different elements. The first one has been the need to guarantee respect for the principle of the sovereign equality of a state, which is the very foundation of immunity of a state official from foreign criminal jurisdiction. In fact, providing immunity under international law to state officials generally seeks to ensure their ability to represent their state or to exercise state functions. And as a consequence, the immunities accorded to state officials are not granted for their personal benefit, but to protect the rights and interests of the state. Secondly, the Commission I have borne in mind also that under the principle of sovereign equality of a state, the foreign state has the right to exercise its own criminal jurisdiction, and that there is a close relationship between jurisdiction and immunity, since immunity from foreign criminal jurisdiction can only be understood vis-a-vis the exercise of criminal jurisdiction. Third, we have considered that immunity of state officials applies in the international legal order, which is a legal and congruent system. Therefore, in the elaboration of these draft articles, consideration has been given to existing rules in different areas of contemporary international law. In particular, we have considered that account must be taken of the strides made in international criminal law in terms of defining and punishing the most serious crimes under international law, on defining the principle of accountability as one of its constituent elements, and consolidating the fight against impunity as a goal of the international community. The Commission is aware that the terms immunity and impunity are neither equivalent nor interchangeable, but we have considered that it is important to avoid that the immunity of state officials from foreign criminal jurisdiction results in impunity for the most serious crimes under international law. Fourth, the Commission has also borne in mind that under certain circumstances, the exercise of criminal jurisdiction over officials of another state may be politically motivated or abusive, which in turn would create undesirable tension in the relations between the foreign state and the state of the official. From this perspective, we have considered that immunity of a state official from foreign criminal jurisdiction may contribute to the stability of international relations. Fifth, as a result of the previous thoughts, we have paid a great attention to the need to guarantee a balanced approach to all the relevant issues related to the topic. In particular, the various rights and interests of states, and at the same time, the different principles and legal values of international law that could have been affected by the draft articles. This concern has been particularly relevant regarding the relationship between draft Article 7, setting up a kind of exception or limits to immunity ratione materia, and the procedural provisions and safeguard contains in part 4 of the draft articles, which are the element for get a balance between all the issues in presence. And finally, I would like to draw your attention on the fact that the ILC has elaborated the draft articles on the understanding that the Commission has a double mandate, develop the progressive development of international law and codification, and as a consequence of that, the draft articles contains both rules on immunity, on codification and progressive development of international law. Having in mind this kind of this criteria, which are on the base of the work of the Commission and are the foundation of the work of the Commission the ILC has adopted draft articles organized on 4 parts. The first part include the scope, refers to the scope and definitions. Is a very important part of the draft articles. I will make some reference to that in a second, but I would like to call your attention in particular to draft article 2, which include 2 essential definitions on the terms of state officials and on the term of act, fulfill, in perform, sorry, in an official way. The second part is devoted to immunity ratione personae. The third is address the immunity ratione materia, and finally, the part 4 refers set up a group of a set of draft articles of procedural nature, which are, I think, the most innovative element in the process in the draft articles adopted by the Commission. After having said that, let me make some general comments in order to describe to you the key elements that identify the draft articles adopted by the Commission. The first key element is the fact that the draft articles is understood as a general and autonomous regime. The purpose of the draft article is to define a general legal regime of immunity of a state official for foreign criminal jurisdiction, letting aside the existing special regimes, for instance, diplomatic immunities, consular immunities, etc., and which are that are applicable to immunity before national courts, but that are submitted to a specific treaty regime. In usually treaty, it is possible to apply some customary regime, but in most of the cases, the special regimes are treaty regimes. And at the same time, the draft articles want to let aside the regime applicable to immunity before international criminal courts and tribunals. On that basis, for establish these general regimes, Article 1 paragraph 1 refers to the three elements defining the scope of the draft article, namely, first, who are the persons enjoying immunity, of course, state officials. Second, what type of jurisdiction is affected by immunity, criminal jurisdiction. And third, in what domain does such criminal jurisdiction operate, which is the criminal jurisdiction of another state. The Commission has been aware of the existence of special legal regimes of immunity of state officials, to which I have made reference before. Those special regimes, well established in international law, should not be affected by the draft articles, and for this purpose, without prejudice clause is contained in paragraph 2 of draft article 1. On the other hand, the Commission has considered during the last 10 years the relationship between the draft articles and the international criminal courts and tribunals. And finally, there have been a great debate about the consideration whether we have to consider or not to include or not a reference to immunity before international criminal tribunals. And finally, the Commission decided that, in fact, there are two different and separate regimes. Even though it has been decided that it was necessary to include a reference to international criminal tribunals in the draft articles, in particular because of the essential role that they are playing in the international legal system. That is reflected in paragraph 3 of Article 1, in accordance to which the draft articles does not affect to any rights or obligations of state parties in an agreement establishing an international criminal court and tribunal. By this way, the Commission intends to keep aside the regime, the specific regime of international criminal tribunals, in order not to undermine or diminish the importance of this kind of jurisdiction. The second element the second key element is the distinction between state immunity and immunity of state officials. The draft articles has understood the immunity of state officials as an autonomous category separate from the immunity of states. Therefore, this immunity is submitted to its own legal regime that can be different to the rules applicable to the immunity of a state. However, it must be recalled that the immunity of a state official is recognized in benefit of the state, who has the last word regarding the invocation and waiver of the immunity. In addition to that, the existence of a link between the state and the state official and between the state and the acts covered by immunity, in particular in the case of immunity ratione materia, is needed in order to apply the immunity. The third key element of the general regime set up by the draft articles is the distinction between immunity ratione personae and immunity ratione materia. This distinction has been established by the Commission from a normative perspective, not only from a conceptual one, taking into account the different positions held and the different functions performed by the different state officials. Both types of immunities are defined in the draft article, having in mind three different elements: who are the state official enjoying immunity; second, what are the acts covered by immunity; and third, when the immunity applies. Anyway, even if these three elements are taken in consideration for identify the immunity ratione materia and immunity ratione personae, the different rule regimes applicable to each of these kind of immunity of a state official has a consequence, the distinction between them. On the basis of these elements, it is possible to identify 3 criteria for distinguish immunity ratione personae and immunity ratione materiae. First of all, immunity ratione personae applies only to several state officials mentioned eu nomine in the draft article, so the head of state, the head of government, and the Minister for Foreign Affairs. On the contrary, immunity ratione materiae applies to any state official, including the former head of state, head of government, and Minister of Foreign Affairs, and they are defined in draft Article 2. In any case, to determine if an individual is a state official has to be made in a case-by-case basis. The second distinction is as follows. Immunity ratione personae covers both private and official acts. Instead, immunity ratione materiae covers only acts performing an official capacity. Those acts are defined also in draft Article 2, and the qualification of an act as performing an official capacity has to be made in a case-by-case basis in order to identify if the state officials is exercising any act that include related with the authority of a state. The third criteria that make a distinction between immunity ratione personae and immunity ratione materiae refers to the term of application of the time for application of immunity. Immunity ratione materiae applies only during the term of office of the state officials, but immunity ratione materiae has no temporal limit. And I would like to add one more distinction between the immunity ratione personae and immunity ratione materiae, as they are included in the draft articles adopted by the Commission. Immunity ratione materiae is not submitted to any limitation or exception, but immunity ratione personae, is not submitted to any limitation or exception, but immunity ratione materiae doesn't apply with regard to crimes under international law listed in draft Article 7, to which I will refer immediately. The 4 key elements that characterize the draft articles is the inclusion of limitation and exceptions to immunity regarding crimes under international law. And the limits and exceptions to immunity has been one of the most controversial elements of the topic, having generated an intense and interesting debate, sometimes a strong debate among the members of the Commission and also in the State Committee. As you can know, the views of the members of the Commission has been divided regarding the adoption of a provision related to the exceptions and limitation to immunity, and as a consequence of that, draft Article 7 was provisionally adopted by a recorded vote in 2017. This method for adoption of decisions by the Commission has been used for the first time in 2017, after more than 20 years when the Commission never vote regarding with regard to adoption of these decisions. The reasons supporting each of the views maintained by the ILC members are very complex. They are recorded. You can find these reasons in the commentaries to draft Article 7. But in particular, and I can't explain all of them now. Probably we can have the opportunity to address this issue during the debate. But at least I would like to call your attention on the different approaches to whether it exists or not, a basis on the contemporary international practice to exclude the application of immunity with regard to the state officials involved in the commission of crimes under international law. So for most of the members of the commission, there are at least a trend in international practice in favor of exception and limitations to immunities, and that is really of great importance now, in particular after the situation in Ukraine. But for other members, this practice that doesn't exist, so the Commission has not the capacity to deal with this issue in the draft articles. Finally, after a long and deep debate, the Commission has decided to include a provision for ruling on the exceptions and limitations to immunities. This provision is the draft Article 7, which applies, I would like to emphasize that, only to immunity ratione materia. In accordance to this article, immunity ratione materia from the exercise of foreign criminal jurisdiction shall not apply in respect of the following crimes under international law: crime of aggression, crimes against humanity, war crimes, crime of apartheid, torture, and finally enforced disappearance. With regard to the scope of these crimes, the Commission decided that no need to define them exists, but in order to avoid in the future any possible legal insecurity or uncertainty, it was agreed at the same time the adoption of a list containing the main instruments where the definition of the listed crimes is included. The list is contained in an annex of the draft articles that must be read together with draft Article 7. Before finishing with the issue of immunities, of exceptions and limitations, let me say a few words about the draft articles, about the drafting and scope of draft Article 7. First, draft Article 7 doesn't make any reference to the word exceptions or limitations in order to capture the different approaches existing in the practice and literature on the nature of this type of crimes, and in particular whether they can or not be considered as act performed in an official capacity. I would like to draw your attention on the fact that for several scholars and now also for several states, for example, torture is not an act performed in an official capacity, but they are a great debate about that. In fact, if you look at the genocide, war crimes, crimes against humanity, torture in particular, it's very difficult that a state official could perform this kind of act without some kind of support from a state. So it is possible to attribute that to a state, but in order to avoid that debate in the draft articles, the Commission have decided to use the expression "shall not apply" that covers both the concept of exceptions and the concept of limitations. And secondly, regarding the scope of draft Article 7, the Commission has decided to limit its application to immunity ratione materia. It is not applicable to immunity ratione persone because of the relevant position of the state officials enjoying this type of immunity. However, it doesn't mean that a former head of state, former head of government, or former minister for foreign affairs are excluded of the application of draft Article 7 when the regime of immunity ratione materia were applicable to them. And the last key element of the draft articles is the inclusion of procedural provisions and safeguards in Part 4 of the draft articles. Part 4 of the draft articles applied in connection with the immunity of state officials from foreign criminal jurisdiction. In fact, the inclusion of this procedural provision and safeguards are of great relevance. I think that it is one of the most innovative components of the draft articles. Actually, international instruments that refer to the immunity of a state official from foreign criminal jurisdiction have generally been confined to stating that immunity exists, identify those who enjoy immunity, defining its scope, and in certain cases, establishing rules on the waiver of immunity, without including any other provision of a procedural nature. Nevertheless, the Commission has considered that the present draft article should include procedural provision and safeguard, supplementing the provisions included in Part 1, 2, and 3, and that for several reasons. First of all, the need to maintain a balance between the rights and interests of the state of the officials and the rights and interests of the foreign states, as in both cases, such rights and interests are directly linked to the principle of sovereign equality of states. Second, the inclusion of procedural provision and safeguards offered to states involved, both the state and of the official and the foreign state, some useful instruments to facilitate reciprocal communication and cooperation regarding a particular sensitive issue, such as immunity of one state officials. In this context, the procedural provision and safeguards are intended to promote mutual trust and the stability of international relations. And third, the procedural provision and safeguards are meant to ensure that the exercise of criminal jurisdiction with regard to an official of another state is not abusive or politically motivated. On that basis, procedural provisions and safeguard gives an added value to the draft articles and helps to strike a balance among the different provisions contained therein. The procedural provision of safeguards apply generally to all cases where the clear question of immunity of a state official from foreign criminal jurisdiction arises, but they are especially important in cases where immunity from foreign criminal jurisdiction may be affected by the provision of draft Article 7, which refers to limitation of exceptions to immunity. The Commission has duly taken this circumstance into account, which is adequately reflected in the text of draft articles containing in Part 4, and in particular is addressed in draft Article 14. Part 4 consists of 11 draft articles dealing respectively with, first of all, the scope of Part 4 and its relationship with the rest of draft article. Second, the procedural provisions of safeguards that apply in the direct relation between the foreign state and the state of the official, in particular draft Article 9 to 15. Third, the application of rules pertaining to the right to a fair trial and the procedural safeguards applicable to the official of another state in respect of whom the question of immunity arises, in draft Article 16. And finally, Part 4 contains a list of mechanisms for facilitating consultation and the settlement of any dispute that may arise between the foreign state and the state of the official with regard to the immunity from foreign criminal jurisdiction of an official of the latter state. I'm referring to draft Article 17 and 18. Regarding the instruments defined in Part 4 as means to guarantee the due balance between the right of foreign state and the state of the official, it must be highlighted in particular the following. First, the obligation of the foreign state to consider the issue of immunity as soon as possible. Second, the obligation for the foreign state to notify to the state of the official the intention to exercise its criminal jurisdiction over one foreign official. Third, the rules applicable to invocation and waiver of immunity. Four, the recognition of a right to ask for information, both by the foreign state and by the state of the officials. Fifth, the rules, that is the most important probably, the rules applicable for determining the immunity, both generally and in particular if the state official is considering the application of draft Article 7 in relation with immunity. The part 4 include also a draft subparagraph related to the possibility for transfer of proceedings. And finally, it includes the obligation to consult each other regarding a case where immunity is addressed. I would like to add another tool of a different nature contained in draft Article 7, a system of, in a certain way, for settlement of disputes between the state of the official and the foreign state. Well, I think that with that explanation, you could have a general view of an overview of the draft articles, and finally I would like to make some general comments as an instrument to set up, to summing up the content of the draft articles. Draft articles refers only to immunity of state officials. Draft articles refers only to immunity from criminal jurisdiction, and the draft articles is set up on the basis that it is needed a balanced treatment between the interests of the state of the official and the state of the foreign state. And in any case, the draft articles takes into account the fact that immunity is not equivalent to impunity, but at the same time takes into account the fact that immunity is a good instrument, but it must be a limited instrument if we want to keep and to guarantee that the principal values, legal values, and principles of international law, in particular related with the international criminal law, which is very important in the present situation, and in general is very important for international law, will be guaranteed as essential elements of the international law at that moment. Thank you very much. I'm sorry for having been late in connecting with you, and I open Nilufer, Patricia, I'm open to any question, any comment from the participants on the seminar. Thank you very much for your attention.
Dear Concha, thank you so much for your excellent summary, really, of a very complex work that has taken many years on an extremely complex, important, and at times controversial topic. And I know, of course, in particular, draft Article 7. So you've done an absolutely brilliant job. And it's very early as well in New York, I should add. So thank you. Now I already see we have some hands up and a question in the chat. But let me, for the hands up, I see we have Dinesao, is that right? Please, good day to you. Coming to us from Ethiopia.
Yes, from Addis Ababa. Thank you, Professor. Really, it's a very wonderful chance to get this insightful ideas and knowledge about this controversial issue. Also, thank you, Professor Nilufer. My point is related to the exceptions about immunity of head of state, head of government, and Minister of Foreign Affairs. I am clear with, I can understand head of state and head of government. They have, of course, they are higher officials, even in our country's local jurisdiction. There are levels of higher officials, so that, but Minister of Foreign Affairs is the same as like Minister of Defense and other ministerial levels. So why this Ministry of Foreign Affairs included exceptionally from other ministers? What is the criteria? Thank you very much.
Thank you for your question. It's a very, very relevant and important question. In fact, we have had this debate in the Commission at the moment when we adopted draft Article 3, identifying the state officials enjoying immunity ratione persone. I think there are several reasons regarding the inclusion of Minister for Foreign Affairs in the list of ratione persone regime. But probably the most important is that the fact that they are not in the same position that the other ministerial post. For one reason, Minister for Foreign Affairs represents a state on the basis of international law, not in the basis of national law. It is possible that a Minister of Defense, a Minister of Trade, or a Minister of Culture can perform activities at international level, but when they perform this kind of activities, that is because the national national legal system attribute to them these functions. We need for the Minister of Defense to perform an activity at the international level. We need that the cabinet or the president of the government or anyone, in accordance only with national law, attribute to them, assign today this function. But that is not the same for the Minister of Foreign Affairs. The Minister of Foreign Affairs has the capacity of the competence for representing the state in international relations, always. Is not a personification of a state. Of course, I don't like this word, but I know that it is used in some occasions. It's not that it represents a state only on the basis of, in particular, on the basis of international law. It is appointed in accordance to the rules of the national law, but when a Minister of Foreign Affairs is appointed, he has several competences because of the international law. And the framework, for example, of the law of the treaties, look at the Vienna Convention. In the framework of international, the responsibility of a state, in the framework of the representation before international organizations. So I think that they are sufficient basis for make this distinction. Yeah, I know that they are an open debate about the possibility to exclude the Minister of Foreign Affairs. But if we exclude the Minister of Foreign Affairs of the regime of the ratione persone regime, we should be obliged to think about a third regime for this kind of person. And I think that is the most important to have a clear picture about the distinction. I can agree with several statements from the state and from the academia saying that the Minister of Defense is in the same position. Not at all, not at all. And it's the same for the Minister of Trade. It's true that several domestic tribunals have recognized immunity to this kind of ministers, but regarding the Minister of Foreign Affairs, regarding the head of state, and regarding the head of government, no debate exists. I don't know if I have, we can find more elements to make such a distinction, but I think that is the most important one.
Great, wonderful. Thank you for the question and the very clear and detailed response. We have a question from Nelly from Armenia. Dear Professor, could you please explain the situation, for example, in case of ICC statute, when the states signing but not ratifying the statute are trying to escape from international responsibility? So in terms of, I guess, of course, there's the immunity issue in the ICC statute, but if they haven't ratified it, what does that do? And I guess does that have any relevance as well for draft Article 7, for example?
Yeah, well, I think that they are different issues. That issue is not covered by the draft articles because as I stated before, the immunities before International Criminal Court and on other international criminal tribunals are submitted to a special regime. But when your question, I think that is more related to the current situation in several in Europe, but one state regarding the distinction between signing and ratifying a treaty is so clear. A state can sign in and decided not ratified or only be silent about that. This situation has took place in several occasions. I can remember at least 3: the United States, Israel, and Russian Federation. Both these three states signing the Rome Statute, and they using the procedure set up in Vienna Convention on law of the law of the treaties. They have notified they have notified the depositary that they don't intend to ratify. What is the purpose of this notification? To be free from the duty to not take decisions against the possibility to the enter into force of the treaty and the possibility to the application of the treaty, but that's all. In fact, they were not under the obligation from the ICC by the fact that they have signed the treaty. From the perspective of the responsibility of the international responsibility, I think that is a different issue. By the declaration, by the notification from US, Israel and Russia, they become free from any obligation to not oppose to the enter into force, etc. But they could remain responsible because from their activities related to the elements contained in the Rome Statute. For example, the ICC will not be competent as a general rule. I would like to remark to underline that they are not obliged. They can be their nationals can be prosecuted by the ICC as a general rule, but the state could be responsible for crimes against humanity, war crimes, genocide. Why? because at the end of the day, the concept of and the content of this kind of crimes have a consuetudinary nature, are customary law, most of them. So I think that we have to make a distinction between the responsibility of a state and the responsibility of the individual, and that is not related with the fact that a state signed and after that decided not to ratify a treaty. I don't know if I have answered to your question.
Yes, thank you. And thank you for providing materials. We will consider it later and more carefully. Thank you so much.
You're welcome.
Thank you, Nelly. And I think we have time for one, maybe another one, but I see that we have a hand up from Jung Woo from South Korea. So please, you can ask your question to Professor Escobar Hernández.
Thank you, Professor. I have a couple of questions. One question is regarding the combatant immunity from international humanitarian law. I'm just curious whether you would characterize that as a functional immunity. Usually when we discuss these kinds of immunities, we are talking about peacetime affairs, such as that state officials like diplomats have. But in international humanitarian law, we also have combatant immunity, which means that soldiers or combatants are not subject to criminal prosecution in foreign courts for their acts of war. I'm curious whether we could characterize this as either functional immunity or personal immunity, because it seems to me to be a little bit different. Because commentators differ on it, but some commentators say that combatant immunity cannot be waived even by states because it's something inherent to the nature of warfare or the nature of combatants. I'm just curious if you have any thoughts on that. Another possibility that occurs to me is that maybe combatant immunity is a kind of a sui generis immunity specific to international humanitarian law. But I'm a bit undecided on that. The second question I have is about the waiver of immunities. I'm curious that if a state official who is being criminally prosecuted in a foreign court, whether he or she can actually waive their own immunity themselves. Maybe they plead guilty in the court. Is that possible, or is it only the state that can waive the immunity? Thank you.
Okay, thank you very much for these two very, very interesting questions. Regarding the first one, I think that we have to, I would like to recall you the judgment of the International Court of Justice in the case immunity of state officials, Germany against Italy, Greece intervening. In that judgment, the International Court of Justice conclude that in fact the act performed during a war, during our conflict, are covered by the immunity of a state, but immunity of a state that is different to immunity of state official. For that reason, the distinction between immunity of a state and immunity of a state official has play a so important role in the draft articles. And the ICJ say in an expressly way that we are not saying anything about immunity of state officials. We are only speaking about immunity of a state. So the act related to the armed conflicts from the perspective of a state could be, can be covered by immunity, but by state immunity. But that is different to the fact of the individual acts performed by members of the armed forces, or not state combatants, not the state fighters, you know. In that case, I think that they are two different issues. First of all, this kind of activities that performed during an armed conflict could be considered as act performing an official capacity. Yes, it is possible. In most of the cases, are acts performed in an official capacity because the member of the armed force will receive orders for the superior, and they are applying these orders. From that perspective, in principle, this kind of acts could be covered by immunity, functional immunity, or immunity ratione materia. I prefer to speak about immunity ratione materia, but I fully understood that you are speaking about the same idea by using functional immunity. But it could be covered, of course, by immunity of a state official from foreign criminal jurisdiction, but with an exceptions. If this kind of acts could be are under the concept of war crimes, genocide, crimes against humanity, etc., draft Article 7, even if they were immune acts performing an official capacity, the immunity doesn't apply. This argument is not applicable to immunity of a state. The act of a state are immune without taking into account other elements. The state could be responsible, but it is covered by immunity of a state regarding the act performing an armed conflict. But it's not the same for the individual. The individual, the state official, the members of the force are covered by immunity, but that this immunity doesn't apply if the acts performing an official capacity can be qualified as crime, war crimes, etc., etc. That is the answer to the first question. And sorry, could you repeat shortly the second one? I forgot it. I didn't take note, and the second question.
The second question was simply whether a state official can waive their own immunity.
Okay, now I remember. Well, the capacity, the competence to decide about the waiver of immunities appertains only to a state, because immunity is recognized, is granted to the state officials on the benefit of the state, not on the benefit of individuals. Well, the case you have put as a sample, the state official recognized to be responsible for this kind of conduct. In this case, it will be very difficult for the domestic court not exercise, does not exercise the jurisdiction. But just for that reason, we have included as a guarantee for the state of the official the duty to notify to the duty that for this foreign state to notify to the state of the official that they intend to exercise jurisdiction, on that they are exercising jurisdiction, in order to avoid that the state official decide about immunity by himself.
Thank you. Thank you so much. And remarkably, this brings us to the end of this very fascinating lecture by Professor Escobar Hernández. And thank you all for your questions as well and your participation. Patricia, I don't know if you wanted to say any final words as I close this session. Otherwise, I will go ahead.
Just to also thank Concha for the excellent overview of the work of the ILC, and also the participants for their excellent questions. I mean, it's a difficult topic, but it's also one that it's very timely and pertinent. And certainly we'll see how the articles, the draft articles, will endure the second reading, and also how they'll be applied by international courts and tribunals and by the states. And so thanks again, Concha, and to all the participants. It was wonderful.
Thank you. Yeah, and I think that I think there's so much more we need to talk about. So perhaps we'll have another special lecture, invite you again to talk about the work of the Commission and on immunities of foreign officials from criminal jurisdiction. Thank you, Concha.
Thank you very much. Thank you, Nilufer. Thank you, Patricia, and thank you all for your attention and for your very, very pertinent questions. It has been my pleasure to be with you, even in a virtual way. Thank you so much. I'm sorry once again for my late connection.
Oh, no apologies necessary. All right, wishing everyone, well, I guess where you are, mostly fantastic evening. For us, we're just starting our day in New York. So see you, well, tomorrow. You will continue your lecture with Felipe Webb. So take care, everyone. Bye-bye.
Bye.